A slip and fall or trip and fall can turn your life upside down. Most people don't even realize that it costs nothing to hire a personal injury attorney. The reason behind this is to allow everyone the opportunity to be able to pursue cases against the big companies and the insurance companies that cause them injuries and that have the money and the ability to pay, but the average person does not have the ability to fight them. So personal injury attorneys will only get paid if there is a recovery. My name is Phil Rizzuto, and I've been representing individuals who have been injured in slip and falls and trip and falls for over 30 years. And what makes me unique from other personal injury attorneys is I've done it from both sides. I have represented large corporations, insurance companies. I've been hired by insurance companies to represent their insureds and defend them in injury cases. I've represented municipalities, and I know what the process is. I know how they evaluate cases, and I know what it takes to get a case resolved. In this video, I'm going to walk you through the process of your fall case so you have a clear understanding as to what to expect. Once we are engaged by you, the first thing we do is send a letter of representation to the individual that is responsible for causing your accident and or their insurance company to put them on notice of our representation of your potential claim. When we send out a letter of representation on a bodily injury claim, it's usually with very basic information. At this point, we know there was an accident. We believe it was somebody else's fault. There was an injury. The extent we do not yet know, but we want to send out the letter of representation as soon as possible so the adverse party knows you are being represented and not to contact you. They should be contacting us. If they contact you, do not speak to them. Give them our information so we can deal with them. In some situations, we will start a lawsuit immediately. However, in most situations, we will spend the next 30 to 90 days gathering information. We'll gather information about the accident. We'll take pictures of the accident location if we don't already have them. We will make sure we get medical documentation to confirm what injuries you have. If there are witnesses, we will attempt to contact the witnesses. So we spend this time learning more about your case. We'll learn more about the extent of your injuries, so we will be in a better position to evaluate your case when the time comes. In every lawsuit, there are 3 factors that are taken into consideration in evaluating cases. 1 is liability. Who is at fault? 2 is damages. What are the injuries that were caused by the person's neglect? And 3 is the ability to pay. That's usually insurance coverage or a deep pocket that can pay for the injuries caused by the neglect. When evaluating injuries, we take into consideration the injuries incurred and sustained from the date of the accident to the present time, and we take into consideration how these injuries are going to affect you in the future over your life expectancy. For simplicity purposes, say a person's life expectancy is 80 years. So if you're 30 years old, we can make a claim for future damages and future pain and suffering over the next 50 years of your life. Third element needed in every lawsuit is the ability to pay. That's usually insurance coverage or a deep pocket that has the ability to pay. In a slip and fall or a trip and fall on someone's property, there usually is a higher amount of insurance coverage available to compensate the individuals for their injuries. In some instances, such as malls or big corporate conglomerate buildings, they do not have insurance and they are self-insured, which means they have a deep pocket and have the ability to pay for your injuries. This sometimes is a blessing and a curse. The blessing is we don't have to worry about the third element because we know there is sufficient coverage to pay for the injuries. However, the more severely you are injured, the more difficult it is to settle the case because we know there is so much insurance coverage available, and we want to make sure we get you the maximum recovery for your injuries. So there really would be no cap, which means your case will take longer, but you'll end up getting more money in the long run. But what is crucial in a situation like this is that the ability to evaluate the case from our end is so important. I would say in most situations, we will know the extent of the liability and the available insurance coverage within 90 days. The more difficult element to assess is the extent of the injuries because it's usually an ongoing process, especially if the injuries are going to be permanent and cause you long-term pain and suffering. In most situations, a good doctor will treat your injuries conservatively, which means they'll send you for physical therapy, pain management. They'll get MRIs to assess the extent of the injuries and the damage, and will attempt to avoid more invasive procedures such as injections or even surgery. If the conservative treatment isn't working, then invasive procedures may be considered down the road. But no matter what your injuries are, we need the medical documentation in order to prove the claim. Pain is not enough. You saying that you're in pain is not enough information for us to be able to prove a case to either the insurance company or ultimately a jury if the case goes to trial. So if you are injured and you are in pain and you do not go for medical treatment, you are limiting your recovery. I hear from clients all the time, I'm still in pain, but the treatment isn't helping. I don't have time to go for the treatment. I go for the treatment, it helps for a day, and then I'm back to being in pain. It is important that this information be documented to show you are still in pain. And no matter what is being done, it's not helping, especially if we're going to make a claim for future pain and suffering and future damages and future medical expenses. This is so crucial because you cannot treat with a doctor for 6 months following an accident and the case comes up for trial 3, 4, 5 years later and you haven't seen the doctor. That doctor does not have the ability to testify that your injuries are permanent and does not have the ability to testify how these injuries are going to affect you into the future. However, in order to begin settlement negotiations, we need the insurance company, the insurance adjuster, or the claims adjuster, or the risk manager to evaluate your case. Sometimes they do this within 2 weeks after getting all the medical records. Sometimes it will take them several months. Regardless of how long it takes them, we cannot negotiate until they have evaluated the case and they are ready to negotiate. Once we have an idea of the extent of your injuries, the liability situation, and the available insurance coverage, we can begin to evaluate the case. But in order to be successful, we need to properly assess your case. There are some attorneys out there that will demand the policy limits on everything. They will make very high, unrealistic demands, which doesn't serve anybody's purpose. The insurance company will never resolve your case. The insurance company knows who these attorneys are and that they're just bluffing and will spend years in litigation because they've made unrealistic demands that aren't anywhere near close to the value of the case. And the longer the case proceeds without an individual getting medical treatment, the worse the case gets. As a defense attorney, I've litigated cases where the clients haven't received treatment in 10 years, believe it or not. Those cases have very, very little value. And it always boggles my mind as to why these attorneys wouldn't settle the cases years ago for realistic numbers. So let me tell you about 2 cases that I currently have. Liability isn't an issue on either one. One involves a woman who sustained soft tissue injuries to her neck and back. Nothing was broken. She has not had surgery. She hasn't had injections. She treated for about 6 months following the accident and then intermittently thereafter. She feels relatively better since the accident. She still has some issues, but she has indicated she is not going back to the doctor. That vehicle has $100,000 in coverage. So we are in the process of resolving that particular claim because there is no real upside. She's not going to go back to the doctor. We know there is a limit of $100,000 of coverage, so likelihood of getting any more than that is very unrealistic. And quite frankly, if she only treated for 6 months, we don't have the medical documentation to support anything more than that, the case is not worth close to $100,000. So we are in the process of negotiating and we're going to resolve that case. The second case is different. The second case involves an individual where there is $300,000 of insurance coverage available. He's been out of work since the accident, which is about a year. He's had 6 injections to his spine, and the insurance company, although they've made attempts to resolve the case, have not made a 6-figure offer at this point. So a complaint has been drafted and a complaint is going to be filed, and we will be litigating that case. Now, that doesn't mean that the case can't resolve once we file a lawsuit, because once we file a lawsuit, the insurance company may get more realistic and say, hey, we don't want to take the risk because they have a big risk. This individual is about 30 years old, so we're going to make a claim for future pain and suffering over the next 50 years of his life. There is only $300,000 of insurance coverage available, so even if a jury were to give him, say, $10,000 over the next 50 years of his life, that's $500,000 $100,000, which is in excess of the insurance coverage. So the insurance company is going to have a problem. They're making the arguments that, well, there's nothing broken, that there are only soft tissue injuries, and probably didn't need to be out of work for a year. They're going to lose that argument, and they will pay more. As you can see from the two examples I just mentioned, there comes a point where a decision has to be made. Are we going to resolve the case, or are we going to litigate the case? That decision is up to you, the client. There are other cases we have where we believe there is a big upside, where there is enough insurance coverage and the client has injuries that they can be compensated over for the next several years of their life, but they refuse to go to the doctor. They say they don't want to do it. They want to settle the case now, and they don't want to be involved in any more litigation. We will honor those requests, and we'll get the client as much money as we can. And if the client is happy, it's their call. In some situations, there may be a disagreement as to the firm client as to the valuation of the case. In a situation like that, where the client is unrealistic, or we think the client is being unrealistic about their expectations, we'll give the client the opportunity to go find another law firm who will be more in alignment with their valuation of the case. So now when we reach decision time and we're deciding, do we settle or we litigate, there are two other potential options available. One is mediation, the other is arbitration. Mediation is a voluntary process where the insurance company and us will agree on a third party to mediate the case and attempt to resolve it. They cannot force anybody to settle the case. Mediation is not binding, but they will get us in a room and they will make attempts to get the parties closer together and ultimately to resolve the case. This is good because if successful, it will avoid years of litigation. And sometimes the insurance adjusters need to have a third independent party put a valuation on a case to cover their butts. It's also beneficial for us and for the clients to hear from an independent person what they think of the case and what the potential defenses are and reasons why the case should be resolved. Again, it's not binding. The only downside is it takes some time, and there is a cost to doing it, which ultimately will come out of the client's recovery. However, we have been very successful in attending mediations and resolving cases, and if you want more information about the mediation process, check out my video on mediations. And arbitration is a binding process where the insurance company and you will agree to have an arbitrator decide the case as opposed to a jury. The benefits to arbitration are that the case will get resolved a lot quicker. Usually an arbitration will be resolved within 6 months to a year, whereas litigation can take 3 to 5 years. It can also be less expensive because in most cases we don't need to hire an expert to come in and testify. We can use their records or their reports. Okay, this is also a benefit and a disadvantage. There are no appeals. So whatever the arbitrator decides is binding, and if you don't like the decision, you can't appeal it. But if the insurance company doesn't like the decision, they can't appeal it either. But there is finality in a much shorter period of time than litigating the case. There are two concerns about each party in a lawsuit. The insurance company never wants to get hit for over their policy limits. The individual wants to make sure that they get money for their pain and suffering and their injuries. So in a lot of situations, we will agree to what's called a high-low arbitration, which means you are guaranteed a minimum amount regardless of the outcome, and the damages are capped usually at the policy limits, and sometimes it's a less amount for the insurance company. It is essentially a win-win because you're guaranteed to walk away with something, and the insurance company is guaranteed not to pay over a certain amount. If the case cannot be resolved, we file a document called a summons and complaint, and we start the lawsuit. Now, how long your case will take depends on many, many factors. The county the case is being brought in, the judge assigned to the case, the number of parties involved in the case, the extent of your injuries and the medical treatment, because the longer you are getting medical treatment, the longer the case may take. So those are just some of the many factors that will determine how long your case will take. In the first year or two, we are involved in a process known as discovery, where we will be assigned a judge to monitor the case. We will exchange information with each other, and that process usually will take 1.5 to 2 years. When we are done with discovery, we will place the case on the trial calendar. In most counties, you can wait for 1.5 to 2 years for the case to come up for trial after discovery is complete. If you want to know more about what to expect after a lawsuit is filed, watch my video on the lawsuit process. If you've been injured in a slip and fall or a trip and fall, ring Rizzuto at 855-Rizzuto. We have represented individuals throughout New York City, all 5 boroughs, all of Long Island, Westchester, and beyond throughout New York State. If you found this information helpful, subscribe, follow, watch my other videos, and I'll see you there.